application and appeal in the matter of the Commissioner for HMRC and Evonik UK Holdings Ltd and others.
Yes, Mr. Lawrence.
Good morning. If it may please the court, I appear for the revenue on this matter. My learned friend, Mr. Brown, of King's Counsel, appears for respondent Evonik. Could I begin by checking the court has all the bundles that we placed before them? It should be a core and a supplementary bundle, and then two authorities bundles, one agreed, one unagreed.
Yes.
I'm grateful. Mr. Bremner and I have discussed timings, and we have agreed a split between us. I have an intended time to sit down, depending on how things go. We have an agreement that if I go beyond that, it's eating into my reply. So hopefully that should not prove a difficulty. Subject to questions from your ladyship and your lordships, I propose to develop my submissions as follows. I'll begin by setting, as it were, the procedural scene, how we came to be before Mr. Justice Richards in the manner that we did. In making those submissions, I will seek to persuade the court of the following proposition, that the Supreme Court, when it made the order that it did, set aside paragraph 1A of what I will call the second Henderson order, second order that Mr. Justice Henderson made following summary judgments. I'll then make submissions on the law about what follows from that, where I will say it follows that my clients were entitled to restitution of the sums paid plus interest as a right. And I'll say that if the court is with me on those two propositions, one about what the Supreme Court did, the other about the law, that is my ground one, that's the end of the appeal. If I'm wrong about that, then I'll go on to discuss ground two, essentially, which is a more detailed consideration of what the judge decided and why I say it's wrong to allocate the sums as he did in 2016, the sums paid in 2016. So, with that, I'll turn to the procedural history. As my lady knows well, and the court may know, the FII GLO that this forms a part of was established in 2003. Evonik's claim is within that. The GLO was set up to establish the lawfulness or otherwise of various aspects of the domestic tax regime as a matter of EU law. And the structure is, if EU law says the provisions are unlawful, then persons who pay money under them are entitled under San Giorgio to remedies. It's then for domestic law to establish what the cause of action is or the remedy should be in respect of those. One of the areas of unlawfulness as established concerned the foreign income dividends regime, or FIDS, as it's called in the vernacular. I wasn't going to go into detail about exactly what the FIDS regime is. I don't think it matters for the purpose of the appeal. The only point is that's one area where tax was paid. The ECJ held the relevant provisions were in breach of the capital and establishment provisions. Therefore, there has to be a remedy. Evonik has other causes of action that are not related to the FIDS. And those are, as the court will have seen, they're called the surplus ACT in my learned friend's skeleton. That's the sort of 8 million.
Yes, can we just be a bit clearer about what those claims are, or is it not relevant?
I don't think it's relevant. They're not claims that were before, they're nothing to do with FIDS, so they weren't money paid as ACT on a FID. They are, as it were, all the other aspects, as I understand it, that are bundling.
But what is the why is there a claim in respect of?
Because the taxing provisions under which the money was paid were held to be unlawful.
And that's a different kind of unlawfulness, is it, from that which was applied to the FIDS or not?
Well, it's the same in that it's all the establishment and capital clause. It's different in that I think it's different provisions that are held to be unlawful, so different regimes under which they're paid.
Part of the reason I'm asking is I don't know whether the label surplus ACT also means that, like the FID regime, where I think it was held that the mere payment of the ACT was unlawful. I don't know if that's the case in relation to all these other elements.
I'm leery of shooting from the hip on that. I'm not sure,
Yeah.
my lady. I think that I'm not sure I should.
I mean, it certainly relates to different payments of tax.
Yes.
and in a narrow sense, different causes of action.
What do you mean by narrow?
You can talk about an entire claim and look at the particulars of the claim, the claim form, and say that's my claim, or you can see that within a claim are a number of causes of action. Indeed, even within the FIG claim, there's a number of causes of action because every payment of ACT is technically a separate cause of action. But what I'm driving at is the FIDs are one particular category of causes of action.
Yes. So
I was trying to understand a little bit what the rest was, but I think we're going to get distracted if we go into more detail on that.
Well, possibly, but it did seem to me to be a part of your argument that these were claims under separate causes of different causes of action, the ACT surplus. And,
I don't
pretend to have got to the bottom of it, but just looking at the pleadings, it looks as though they're different heads of loss arising from what's alleged to be the same unlawfulness. Separate causes of action in the sense one can have separate claims for breach of contract.
Yes.
Separate breaches, but all being the same nature of the cause of action.
Yes.
Breach of contract claim.
I think that's correct. I'm nervous of giving away something that's wrong, but I believe it's the case that the generalised unlawfulness under EU law is Establishment Capital Clause says these provisions breach EU law. There are then a whole host of separate questions as to how the domestic remedy should be established, and those are, I think, quite different. So one of the issues in Supreme Court 3 is whether, for example, there should be carry forward of credits, things like that, and that is completely separate from the FIDs. So there are a host of sometimes called computational issues, but that all go to the question of what EU law says domestic law should give you in respect to the cause of action. And then on the cause of action itself, to some extent it's the same, in that for a lot of them it will be Section 85 interest to satisfy the San Giorgio right. So in a general sense, and the cause of action might be the same, there is a statute which entitles people to so-called period of prematurity interest, but they're still separate causes of action in the narrow sense of my lady, they're different payments, and a broader sense that they're different taxing provisions under which the money is paid.
Sorry, I think you've raised a separate question. The way it's presented is that Section 85 is relevant to the FIDs. Is it relevant to the other causes of action as well?
Yes, I think it could be. Any instance where there is
that's just not how it's presented.
I've not meant to not present it that way.
No, it's not a criticism. I'm trying to understand.
Section 85, the problem Section 85 is to solve is where money is paid as ACT and then set against, for example, mainstream corporation tax. There is then, so the Supreme Court says in Prudential, no common law claim for the time value that the revenue has had in respect to the money. You can't claim an unjust enrichment for the time value of the money. There has then to be a remedy. Section 85 is that remedy.
Okay.
That fact scenario could apply in the FIDs and would, I think, generally apply in the FIDs because it was year to year.
Yeah, no, common ground obviously applies to the FIDs. What I suppose I'm driving at still is the label surplus ACT has been applied to the rest of the claims, and if it was genuine surplus ACT, I think Section 85 might not apply because that assumes a set-off.
So I'd not meant to say it applied. So in surplus ACT claims, those are claims where there's principal
Right.
outstanding.
Okay, let's try another way. Are we right to treat the label of surplus ACT as correctly describing the balance of the claims?
I believe so, yes. And I believe for those instances, then you can never have Section 85 interest because there's never been a set-off.
Exactly.
Yeah, sorry, I now understand.
And for Evonik, I'm asking, is it the case that the claims we've been presented with are indeed the entirety of its claims? Because lots of other claims in litigation have different types of claim, including to unlawful corporations. So we're just talking about ACT.
check. I believe the answer is yes, voluntary.
Evonik doesn't have default.
I believe so. Can we come back to it if I'm wrong? So, the claims that were before Mr. Justice Henderson are the Phillips claims in 2016. Summary judgment is sought in respect to those in 2014. One of the questions that my Lord Justice Popplewell asked was whether the 8.8 million was established at that point. I think the answer to that is no. There were computational questions on how to figure out how much money the test claimants as a whole were entitled to, which were at the time the application was issued still to be heard by this court in what was called FII, Court for Appeal 2. They were resolved in 2016 before Mr. Justice Henderson's judgment, but there was then an appeal to the Supreme Court. Permission to appeal was sought. It was granted in respect to, I think, only one computational issue. And it was only after Supreme Court 3 that there could be finality on the 8.8 million, subject to, as my Lord said, limitations.
So were those the subject matter of what Mr. Justice Henderson referred to in paragraph 80, whatever it was, 82, saying because there was still a question in relation to those, he wouldn't give summary judgment in relation to them?
I need to check the paragraph.
Could I think it's at Authorities tab 9.
It's page 88.
Page 88.
No, my Lord. This is a separate question.
That's a different.
What happens there is you have payment of ACT, which is Corporation Taxpayer in Advance. The thing that Mr. Justice Henderson grants summary judgment on is from the moment of payment until settle for utilisation, they get central metals interest.
Yeah.
After utilisation, but before they're paid, they then want also compound interest.
I see.
And they're not, he says, I'm not going to give judgment on that. He had given it on the merits in another case, but it was on appeal.
But he both related to the Phillips claims.
Right.
The only
Yes,
other claim
yes.
Okay, thank you.
Okay,
That's all.
you just said the 8.8 was finally established in SC3, subject to limitation. Can you what is the current position in relation to limitation? I know that went back.
Yes.
And I know that Mr. Justice Richard's decision on that's been upheld by the Court of Appeal. Is any of the 8 point? I mean, the fact that a final order is being made has been made, rather suggests to me that no further limitation issue could affect the 8.8. But what I'm interested in understanding whether whether limitation was an issue and may remain an issue
Yes.
in relation to the 8.8.
As I understand it, almost all of the 8.8 million, if HMRC's case before Mr. Justice Richards had been upheld, it wasn't, would have been time barred. Is that responsive?
Sorry, say that again.
HMRC had a case before Mr. Justice Richards that the time started to run on.
The BAT case.
Exactly. If HMRC's case had been upheld and it had been before, I forget the precise date, July 1996, something like that, then the bulk of the 8.8 million would have been time.
Okay.
Mr. Justice Richards doesn't uphold that. That's why we then get to, okay, the claims are in time, what are they entitled to? And that's how we end up here.
Okay. So until and what we're referring to is a decision involving BAT Industries that was very recently upheld by this court. Until that decision, which I think was last year, upheld this year, HMRC's position at least was that the 8.8 million wasn't established.
Yes.
as
Yeah, it's two
Boeing.
two minor tweaks.
Yeah.
It's called BAT Industries, but there are a number of test claimants in that, for which Evonik was one of them.
okay.
I don't know why the name changed from FII to BAT Industries. Maybe they were bored of FII number 14, 15 in the court.
So Evonik was actually an active party to that, just
There is an established value for the surplus as
Yeah.
well as for the fence.
How much is this? Sorry, my learned friend has pointed out to me that I think my lady made established value that it is. Those establish the core amount that can be claimed irrespective of the limitation.
Yeah.
That's the amount. I can't remember how much it was that is in dispute, if I may.
It's just under 1.8 million was established. That's Mr. Justice Roger in 2023.
Great. I'm very grateful for that. Just under 1.8 million was established. So that is irreducible, irrespective of HMRC's case on limitation. They get that. But the delta, the balance between 1.8 and 8.8 was in dispute before Mr. Justice Richards in this court. That much is what we were seeking to say was time barred, and we lost before Mr. Justice Richards in this court, and then query what happens next. The court has extended time for permission to read application, none has yet been made. Mr. Justice Henderson then had to, this is largely an answer that I've already given to my Lord Justice Popplewell. There are two things he really had to establish. One was, has it been determined to the summary judgment level that the underlying taxing provisions were unlawful, not of union law? He held it was. That entitled Evonik to a remedy. Separate question, what remedy did it get as a matter of domestic law? And he held, it was common ground at the time, that they are entitled to so-called Sempra metals interest. What that means is, Sempra metals held that there was a cause of action as a matter of domestic law, that one has a claim for the time value of money under the law of unjust enrichment. When I pay money, interest accrues day to day. Sempra metals said you can then claim that interest back under unjust enrichment. Parce, Lapintada, Parce, the older cases. Mr. Justice Henderson therefore held that was the method of quantifying the Evonik remedy, and that's how it was quantified. It's quantified on a compound basis. And he held that only for the period of prematurity as it's described, so the moment before utilisation. After utilisation, he refuses the summary judgment application, says the law is sufficiently unclear. Section 35A, interest is awarded instead. Could we look at the orders he made, because they'll show, I think, that structure, sort of quite structure of his orders. It's supplementary bundle, tab 4, page 29, is the first order after judgment. And this I want is page 30, paragraph 1. Paragraph 1 says the application for summary judgment in respect of parts of the claimant's claims concerning ACT and FITs are granted. You then have at paragraphs 3 and 4 methods for computations to be agreed. That is not done at this point. Computations are always a challenge in this case. So you then get the second order he makes, which is to specify how much has to be paid. That's at page 33. And could I draw your attention to the first recital, where the order is defined? That's the order we just looked at, the first Henderson order. The crucial paragraph, I think, for today's purposes is then paragraph 1, which is page 34. In settlement of paragraph 1 of the order, that is the summary judgment determination, the defendants pay this much money until this date, and thereafter banked plus 2%. So that's the 35A award rather than the compound interest award. Little a is the paragraph that concerns us today, because that's the Evonik's amount. This order then ends up going on appeal to the Supreme Court and Supreme Court 3. And so the first thing I wanted to show is what was before the Supreme Court at that stage. And I think the best order to see is the one at Supplementary Bundle 8, page 47, which is the order granting permission to appeal. So the second order, the important order granting permission to appeal. Page 47 it begins, and the relevant paragraphs are on page 48. So subsection 2, then Romanet 3 and 5. Sub 3 is permission is granted on issue 10 insofar as it relates to the Sempra issue. And over the page, issue 10 is FIDS and summary judgment. And what it means, the Sempra issue there is there was an entitlement under San Giorgio to a remedy. What should that remedy be? Mr. Justice Henderson held Sempra Metals. The remedy then wanted to say, because that's wrong, because Sempra Metals has been overturned in the Prudential case. So you shouldn't get that anymore. Instead, you should get something else. At this point, the Finance Act had been passed, so.
But it was it part of the revenues case that there could be some compensation for the time value of money?
Yes, it had to be, because San Giorgio, in the sense that's the EU cause of action, San Giorgio says they have to get something for the time value. The question is, what is adequate? Does it have to be simple, compound, what rate?
So it was the revenues case that the Henderson paragraph 1 order was an over modification, but not that nothing was due in relation to the time value of the FID claims. So it would need to be reduced rather than eliminated. Is that right?
It's true in one respect that there would have to be, to satisfy the entitlement to San Giorgio interest, there would have to be an award paid. The revenue didn't say that that paragraph had to be reduced, because that paragraph is recognising Sempra claims, which is an English law cause of action that didn't exist. So the revenues case was those were improperly entered because there's no cause of action in Sempra. And that's why we'll come to this. That's why it has to be set aside, because it's saying it's the wrong claim. It should have been a Section 85 claim. The result is, yes, the revenue says you can have, we'll give you Section 85 interest. See, my lord's not happy.
But I thought you told us that actually Section 85 was only enacted later, so it would have had to have been a different basis for quantification.
What do you mean
than
by
Section 85?
Why would it have to be a different basis?
I thought you said that at that time Section 85 hadn't.
No, it had been. So this is July 2019 that this order is made, and I think it's February 2019 that the Finance Act is passed. So, I mean, at this point, it's just permission to appeal. So,
yes, but sorry, when Mr. Justice Henderson made his order.
At that point, it was common ground, it was Sempra Metals. Sempra Metals was the law. So HMRC at that point was not. I'm not sure if I'm responding to my lord, so please do say what I'm missing. Before Mr. Justice Henderson, HMRC accepted Sempra Metals was the law and was the proper method.
I understand.
Later, it gets overruled. HMRC then wants to say, that order is on appeal, we therefore want it set aside, because that shouldn't be the right remedy. There's then a question, my learned friend says, and the test claimants in general said, you shouldn't be allowed to do that because you weren't challenging it at the time. So it was an abusive process, things like that. The Supreme Court had to adjudicate all of that to help with us, we weren't abusive. They then have to say, what remedy are they entitled to? And my learned friend's clients again wanted to say, the determination ought to stand that they were entitled to a remedy more than the Finance Act. And one of their arguments is, well, it must have existed at the time, so we must be able to, suppose the Finance Act is passed later on. Things like that. The Supreme Court says, no, you are entitled to the Finance Act. Even though it's passed later, what you get is Finance Act interest. Why? Because the moment when they have to, the Supreme Court has to make the order, is the moment that they are required by EU law to ensure an adequate indemnity is given. The Finance Act is an adequate indemnity. Therefore, their order is you get Finance Act interest. Is that?
That's clear. Thank you.
I've somewhat anticipated this, but I think we should, if I may turn to the Supreme Court's decision, which is in Authorities Bundle 12 at page 144. And a few points to pick up on this. Paragraph 8 at page 154, the Supreme Court notes that Sempre Metals has been overruled. That's, as it were, the legal context for all of this issue that I'm discussing at the moment. There are other issues in the case. But paragraph 50 to 51, which is at page 163, then there is the summary of, as it were, our little dispute for this, the FIDS and summary judgment aspect. And I think that's giving a bit more detail on the procedural history of how it ends up before the court, but hopefully is consistent with what I've said this morning. Paragraph 56, which is a little bit further down, 56 and 57, is what my learned friend's case was at the time on, as it were, what Prudential did and didn't change in respect of the claims. And I've, in a sense, said already that the bit at 57, my learned friend says that the claimants submit the revenue bar from denying the entitlement. That's the abuse of process, res judicata, those points. And then there's the fallback. If they lose on that, they should get Section 35A interest, not Section 85 interest, because the rates are different. And I've also, I think, said this, that the Supreme Court says that's wrong. I'll come to that in one moment. Could I also, though, draw your attention to paragraph 114, which is on page 178. It's a description of Section 35A and how it works. It may become relevant to what I'm going to say today, so if I could just ask you to read that, that would be helpful. The conclusion is then, my learned friend's case is rejected. Paragraph 118, page 179. The Supreme Court says the appeal is allowed on the issues I showed the court earlier. The summary judgment should also be set aside. And the cases in question remitted to the High Court. That's then repeated, but in a slightly different procedural language at page up 210, paragraph 234, where we're told the summary judgments, we would recall the summary judgments.
So sorry, which paragraph was that?
234, page 210. Very interesting. I didn't know that language before I read that decision, but the explanation is Lord Reed and Lord Hodge are the authors, and that means set aside under Scottish procedural law. Well, the summary judgments have to be set aside on the Semper issue. Semper is not the law, so you can't have an order that has merged causes of action that didn't exist. They have to go. What isn't set aside is HMRC's liability under the FIDs as a matter of EU law. They're still liable to a San Giorgio remedy. But what is set aside is the domestic law analysis of that. And we can see that in the order that the Supreme Court makes, which is in the supplementary bundle, tab 9, page 50. The second declaration, Romanet 1, HMRC's appeal is allowed on issue 10 and 26. And then further down, sorry, I don't think there's a declaration, that's an order. Further down, paragraph 4 of the order, page 52 of the bundle. The summary judgments are set aside, limited to Semper issue, to that extent only.
Sorry, I thought, isn't it 2-1 rather than 1?
I meant to say 2-1.
2-1, not 1-2, isn't it?
Yes, sorry. Page 51.
2-1
2(1), HMRC's appeal is allowed on issue 10 and
and
26.
4.
And 4. Those are the key paragraphs. And so the first question, this is the burden of the first submission I said I wanted to make good this morning, is what does that paragraph do? And in view of what I've said this morning, I said to this, there is EU law unlawfulness. The FIDS regime is unlawful. That wasn't challenged by HMRC. There's a San Giorgio right. However, the cause of action in domestic law that gave effect to that right doesn't exist anymore. That's what Prudential decided on Semper. And therefore, the quantum is wrong. And so when they say set aside, to that extent only, what I say is it sets aside paragraph 1A of the second Henderson order. It doesn't set aside the determination that the regime is unlawful, because that wasn't before the court. I think that's tolerably clear from the language. It's what the words say, they're set aside. It's also right in principle. I showed.
So, just to be clear, you're saying that to the extent gets at preserving the bit that declares that the regime is unlawful, rather than saying, for example, you just overpaid, and we now know you should have paid an amount calculated under Section 85 only.
Yes.
So which, sorry, go on.
Because, sorry,
No, you go on.
Because if it was saying, we know you've overpaid, now pay this amount, then the language use would be varied. The order is varied to that extent. They have to set aside a paragraph because it's recognising causes of action that don't exist. The whole summary judgment on that goes, what they're entitled to is the Section 85A interest. And the burden of the Supreme Court's decision on the EU law was that Section 85 is an adequate indemnity. So they're saying, standing back today, if you get Section 85 interest, your San Giorgio right has been satisfied. That's my submission.
So which parts of the order come within the qualification as not being set aside?
The first Henderson order, which is page 29 of the bundle, in a sense, all of it, but paragraph 1 of the operative part, the applications are granted. That seems to me to be the right.
So that's not that's not set
That's
aside.
not set aside. I thought that was your lordship's question. Which parts do not fall within it?
Okay, I'm not sure that fits with what you've just said, because you're saying you haven't set aside the entitlement to summary judgment. In fact, the granting of summary judgment.
Well, so it is difficult to know exactly which parts the Supreme Court meant to set aside because they haven't clearly distinguished between the EU law unlawfulness and the domestic law remedy. What I couldn't say is that HMRC could have come back to this court, any court, and said actually the FIDS regime was lawful. That's the thing in the abstract that the Supreme Court was meaning to preserve. It seems to me that a plausible reading of the orders is that the division is between the first and the second, and the first is saying you're entitled to a remedy, the second is saying what the remedy is. If that's wrong as a reading of the order, there must be something else set aside, but which does preserve, and it has to preserve the entitlement to a San Giorgio remedy, because that is not being challenged.
Well, I think that's the case against you. That all the Supreme Court order means by to the extent that is that it's set aside to the extent that the quantification was in accordance with SEMPRA.
Well, it can't be sorry.
On a compound basis, and it only sets it aside to that extent.
Yes, it can't be just that though, because the order must be recognising causes of action which don't exist. So what they've said is you weren't entitled to those causes of action then. You also weren't entitled then to Section 85 interest because it hadn't been passed. So what do they mean when they say set aside? In a sense, my learned friend's case is when they said set aside, they meant varied. I said that's not what they say. It makes sense that's not what they say because that doesn't fit with the structure of what the appeal was about.
Well, neither of you, as I understand it, are putting forward what my lord is suggesting, which is that what the Supreme Court may have intended to achieve was you got too much because of those orders, because it was calculated on the compound basis, do the recalculation on the Section 85 basis. That's
right, neither of us are. It is a...
Well, okay.
It is a way that, of course, if you were to read the Supreme Court order as varying Mr. Justice Henderson's second order, what that would mean is you then have to plug into that order the FIDS under Section 85. And then my case would be, I get the rest. So we then
I appreciate that.
But it's true, neither of us say that. We don't say that because we say set aside means what it says on the tin. My own friend doesn't say that because he wants to hold on to as much money as possible.
At some stage, I'm sure one of you will come on to this. I do want to understand how this would fit in with other claimants and the position of claimants who may, for example, only have fit causes of action or have ones. I don't want to take you out of your course.
No, it's fine.
But in trying to understand what you're both contending for, and I'm very conscious this is group litigation, even though the judge didn't make this a glare issue on this occasion. I do want to understand that one.
This is also my lord's second question, so there's no reason not to deal with it now. There are no claimants left in the GLO with big claims only. As the law stands today, as I understand it, there is only one case where the FID claims are likely to exceed surplus ACT.
Sorry, yes, so there are no claimants left?
With only FID claims. There is only one case where FID claims are likely to exceed the surplus ACT. I think that was the second part of my lord's question, which is Investis. In the court will see it, paragraph 1b of Mr. Justice Henderson's second order, page 34. Investis has 81 million of ACT. So that's a relative amount relative to the other ones. So I think the answer is, to my lady's question, the sort of intention behind it is, I don't think this is going to be something that's going to have broad ramifications within the GLA.
If we're going to be decide the meaning of paragraph 4 of the Supreme Court's order, understand what is meant by summary judgments. Where do you find where that is defined, or how will you determine what that means?
I don't think I'm going to be able to do better, Your Lordship, because in the judgment that I showed you earlier. They are thinking about the FID summary judgments. The way it's argued before the court is, do they or do they not get Semprametal's interest because of the res judicata? Do they, or if not, what do they get? I am not aware of greater clarity than that for what the Supreme Court's order can.
Do you say that summary judgments are the orders at tab 4?
Yes.
And are they two distinct summary judgments?
No. It's one summary judgment overall that's determined, in a sense, three
Why do they
things.
say summary judgments plural?
Oh, sorry. There are, well, I think that the answer to that is that there are multiple summary judgments under the second one. If you, there are
Because
all
of multiple claims.
Yes. So all of those different orders are being set aside. That's my reading of that.
And the second question is, in relation to the set aside to the extent only, taking 1A, which is a money judgment specifying particular sums, it seems to me that it isn't a sensible interpretation of that. What the Supreme Court were doing was setting aside those sums, but substituting them with ascertained lower sums.
But I hope I'm understanding. That's my submission.
Yes.
Yes, I agree. That's my case.
I'm suggesting that you must be right in that. I think it was being suggested to you that that's maybe.
Yes, it is. And I tried to resist that and say, I don't accept that. I say it's set aside entirely. What I then wanted to do is say, if I'm wrong about that, if I can't convince at least two of you, then it doesn't follow that Mr. Bremner wins. What should follow, I'd say, is that I would get the remainder of the balance. So we overpay by 6.4 million. If this becomes 2.1 million, I should get the 4 million plus interest back. But that was meant to be a subsidiary case. My primary case remains firmly not an inch back from set aside and set aside.
And one last question on what the order means. What do you say is remitted?
Quantification. So it was not, it took a while to establish exactly how much they were entitled to under both the Section 85 and the remainder of the claims. So they had to remit, well, they had already remitted.
They didn't remit the non-FID claims under this order, did they?
No, all of those had been remitted by Supreme Court 2, I think, because the limitation issue was had already remitted the determination of the limitation issue. If I'm in English,
I really didn't want to interrupt. The remitter that had happened by that point in time was a remitter in the British American tobacco test case, because Evonik had not been a party to the limitation appeal, which produced FRI Supreme Court 2 in November 2020. The Evonik limitation issue is added later, as it happens as a result of directions that my Lady Justice Falk made when she was Mrs. Justice Falk, but it comes in essentially by way of a preliminary issue in the Evonik claim, and that happens later in time. If the date matters, we can check. I didn't want to interrupt.
So going back to this remittal, which is my Lord's question, that was surely in relation to the FID summary judgments.
I agree. Yes. So maybe I was reading too constructively the Supreme Court's first order. My assumption was when the BAT claim is remitted, that is in terms of all the surplus ATT things. When claims are then added to that test case, it must be that those then have to be determined on the same issues. Evonik is added as a test claim.
Yes. So Evonik's not a party to SC3.
Well, it's a test
Well,
claim at the
SC2,
highest. It's a
isn't it?
follower. It's not a test claim.
Yeah.
Yes, that's right.
But what I'm interested in particularly is, my understanding is that the judge seemed to be under the impression that what was also remitted to him was the question of what would be done with the 6.4 million. Now, do you or do you not accept that that issue was remitted to him?
No, I don't accept that. This order is only dealing with the FIDs. That's all that is remitted. There has to be a method for Evonik to get judgment, but it's not under this order that they give that.
Sorry, I'm not sure I understand that.
So this order, my lady, the Supreme Court's order that says set aside and remitted, my Lord's point is what is remitted by the matter, or the summary judgments, the claims remitted to the High Court for determination on the basis of this court's findings. The question is, what are the claims? What's the referent of that phrase? The claims must be those in the summary judgments. This is my analysis. Those claims are all FIDS claims, they're not the other ones. So this order cannot be remitting the quote surplus ACT claims.
But it is remitting the 6.4 million,
Well,
effectively. Which is, sorry, I think that's contrary to what you said.
I'm not sure that's right. I mean, what it remits are the summary judgment claims. We then said in our submissions, as you've seen, you don't need to make an order that we get back our 6.4 million because it will follow automatically. As the person who drafted that, I feel a little foolish now. So we didn't ask
So
them.
do you think, is your case that what effectively needed to go back to the High Court was a decision to award interest under Section 85?
Yes, quantification of that. Because they don't have the computations. It's only later you get the computations on it. And they also, the Supreme Court doesn't know how much of those claims might or might not be time barred. They know that limitation is an issue, but there's no evidence before them as to how much they are. There's nothing in before the Supreme Court on what the value would be under Section 85. So they don't want to work that out. It's remitted, someone else go and work it out. That's my understanding of what they're doing.
Okay, so you think what the judge should have done is make an award under Section 85 and somehow recognise what the Supreme Court should be taken to have done in relation to the 6.4.
Well, I didn't say it should be taken to have done because, as I said, originally it was always what happened. It wasn't the appeal courts who did this. It was remitted and there was a writ of restitution before the first instance judge. Well, what he should have done is said, here is Evonik's Section 85 interest, this much. Evonik has all these other claims, we'll give judgment for those. HMRC, though, is also entitled to its money back under the summary judgments that are set aside. He can then...
No, sorry.
No,
But that was a claim that was before him in what way? It wasn't something that had been remitted to him. On what basis was that a claim by the revenue that was before Mr. Justice Richards?
Well, we raised it by way of set-off, so you don't need to issue a claim form to say to discharge this. We want to, essentially all I was saying is we want to partially discharge our liability in respect of the claims Evonik has by way of setting off these very closely related claims of the money paid under.
And while we're talking about set-off, what you said we're entitled to our 6.4 million on this claim. We're entitled, I think you used the words, to interest. Is that what's that interest? It's interest under Section 35A.
Yes, that's what we
You're
said.
making an assumption about the rate. What rate are you assuming?
I am making assumptions about the rate. I think Mr. Bremner is as well. We're assuming that there's mutuality. The reason why I say that's the assumption, Mr. Bremner, one of his, as it were, forensic points is to say, if I'm right, it stops his interest from running. And it can only do that if they're matching rates.
This is base plus 2%.
Correct.
Which base?
I'm giving
Has that rate, I mean, maybe well be under this litigation, the revenue's never had to account back to the taxpayer. Is it really common ground that that there is an entitlement to interest at a particular rate? Or
Well,
really
no,
such a
sorry, it's too strong to say it's an entitlement. It's ultimately a matter of discretion for the court. It's agreed, as I understand it, into the parties that that is the rate HMRC will pay. HMRC has been, the court of course can say, no, it should be much lower. Of course we'd welcome that.
I'm trying to understand what the common ground is at the moment.
Mr. Bremner will be able to clarify his client's case. I have no, as I'm aware, agreement, written statement that his clients agree the rate. I can't go that far. What I can say is his case presupposes it's the same. This goes to one of my Lord's questions, was what could differ between ground 1 and ground 2.
Yeah.
If we were to get lower interest, ground 2 in a sense would be better for me, for the reason that my Lord anticipated. So it would be setting off the higher rate of interest. Now I don't want to argue, I'd rather lose on that and on ground 1, because I think it's the correct position in principle. But that is a world, because the rate would ultimately be for your lordships, where it would be better for me to win on the kind of counterfactual deeming of money paid than it would on my principal case. But that's not the case I'm going to present first, even though it can be better, because I'd say it would be wrong in principle. But that, sorry.
And does it follow from your submission that your entitlement to Section 35A interest, the discretionary entitlement, if one wants to put it that way, that the claim of repayment under the order that's been set aside is a claim in debt? Is that what the Supreme Court was saying in the passage you showed us, that Section 35A only bites on claims in debt?
Yes, so it's a debt because it's a liquidated sum that's due. The other burden of the passage I was showing you was to say there's no entitlement under Section 35A to a debt. So the point there is you can't, as it were, look back in 2016 and say, do you want to ask a question?
Well, I'm just looking at the moment on what your cause of action is for money paid under an order that's been set aside.
Yeah.
And you characterise it as a claim in debt, do you?
Well, debt is something of a chameleon word. It's not a claim in debt in the sense of a contractual debt. I'd say it would fall within, a claim in unjust enrichment can fall within Section 35A. A money judgment can fall within Section 35A. Those are all debts in that sense. Debts there just means sum certain. It doesn't tell you about the juridical basis of the sum certain. I don't make submissions. I've not sought to make this a case about the jural basis of the entitlement. I say it's very clearly entitled. It doesn't matter whether it's unjust enrichment, inherent jurisdiction, or something else. But we do get the money back. I'll come on to that. Or I can deal with it now if your lordship prefers.
No, deal with it when it's convenient.
I think that this colloquy began with my lady's question on what was I saying, what did I say should happen? Yes, I said, take all three, as it were, judgments, the FID's judgment, the ACT plus 35A and ours, and then ours gets set off against theirs, so we discharge part of our obligation by settle. Now my lord asked the question, well, there was no claim. It's true we hadn't issued a claim form, so we didn't think we had to, for the reasons I explained. If we did have to, though, it can't be right to extinguish our claim by means of this retrospective set-off. Instead, the judge should have said, I'm not going to give you judgment on your claim. You don't have a claim form, go away. Come back when you do have one. And we'd have been well within time, given the judgment set aside. But I say I don't need to go there, because it's, so far as I know, never been suggested that when orders are set aside on appeal, people have to go away and issue further claim forms paying the fee for that. It's usually just readjustment.
That's because normally when the court sets aside an order, it will make provisions for what is to happen.
Yes.
And they'll be asked to do so.
Yes.
By the successful party. They'll say, we paid 6.4 million pursuant to that order, we set it aside, we'd like it back.
Yes.
And the court will then not have a general jurisdiction as to the terms upon which it sets aside the order.
It would.
So this isn't going to arise very often, is it?
No. The only cases where it has arisen pretty much are where courts have not been asked to do that for whatever reason, or there's a mistake of fact. And then someone tries to do what my learned friend does, which is to say we're not going to pay. And then in all of those cases, without exception, will come to them that I'm aware of. The court says, yes, you do. Even though it was not illegal, even though it wasn't ours. One of those is the Roger and the Comptoir. Maybe it's worth looking at that now, if I may. That is at tab 14, page 230 of the authorities bundle. My lady has already raised something of an eyebrow to the second proposition I'm going to make. There are two propositions I want to make on the law. One is you get your money back paid under an order set aside as of right. The second, the eyebrow raising one, was that you get interest as of right. I don't need to win on both of those to succeed on ground one to this extent. If I'm right on the first, what the judge did is wrong. Because if I'm right on the first, you get the money back as of right. It's wrong to engage in this fictional deeming of payments to be set against sums in 2016. And then we have to argue about what interest I do get, even if it's not, as it were, as of right.
If it's as of right, why do you have to make a claim or issue a motion or application seeking restitution?
To compel them to comply with their duties. So it's only if they refuse to pay you have to make a motion. Because otherwise they should just pay you. So when I say it's as of right, what I mean is they ought to have paid us that interest.
Well, there must be at least, on your analysis, there have to at least be a determination of what interest you're entitled to.
I accept that. Although
So that's not all as of right, is it?
No, I accept that. So what I meant is we're entitled to an award of interest as of right. The rate is then to be determined by the court.
So even granting any interest is discretionary, isn't it?
Yes, of course. Well, I'm not trying to escape from the words of 35A. That's what I say my right comes under. Right. I then want to put that in whatever sort of scarecrow quotes I have to for these purposes. What I will, I suppose, try to frame it is this way. The courts have expressed a very strong policy that when this happens, one should uphold that under the statute. So there would have to be very strong countervailing reasons for the court to say we won't exercise our discretion. Hard and weak discretions. This is, I'd say, a weak one. The court cannot decide for whatever reason it wants not to give you interest, because the cases say the proper method of unravelling the judgment is to give interest, and the way that's given effect is under section 35A. Is that clear?
Yes, no, I understand, but you're going to show us the cases.
Yeah.
I think what's interesting, I'm just interested in the way you describe it as an automatic right, because generally if you've got automatic rights, then they follow automatically, not by way of claim which the court hasn't considered. So presumably, if you have to claim restitution, you have to establish a right to restitution on ordinary restitution principles, not pursuant to if it's an automatic right, you wouldn't claim restitution, you'd say, I have an automatic right to the money.
Yes, I can see that my language here clearly infelicitous. I had not meant by automatic to suggest it was more automatic than if we established certain preconditions, we ought to get it, subject to, because it's under the statute, in theory there could be further reasons. I've not meant that it's like a slot machine. But for example, a claim in restitution, I would say, if one has established enrichment at the expense of injustice, one is entitled to a remedy. One still has to establish that.
In a sense, that's obvious.
Well, we say this is obvious. So that wasn't meant to be facetious.
No.
Okay.
Well, maybe, I'm sorry, rather than
Look at the case.
maybe it's the authorities will.
Yeah. The facts of this case are relatively unimportant, but one particular point is important. In the main set of proceedings in Roger, the claimants brought an action in Trover.
Sorry, where are which tab are we
Tab
on?
14 of the authorities bundle, page 213. The defendant is then ordered to pay sums as principal and interest. The claimant then appeals, and the underlying judgments are found to be erroneous. Then I think the first and really important bit is page 231. The Privy Council gives judgment, that's the right term, judgment or advice. By order in council, Her Majesty Queen Victoria orders the judgment of the court below be reversed. The defendant then pays the principal sum and costs, but refuses to pay interest. It goes back to Hong Kong. On page 232 of the authorities bundle, you'll see the Chief Judge of Hong Kong, Chief Justice of Hong Kong, I apologise, agrees there's no power to make an award of interest. So it goes back up. The advice, the judgment of Lord Cairns begins at 238. And could I ask the court to look at the passage on 239? At the bottom of the page, there's a paragraph beginning, the result is this. I'll ask the court to read that paragraph. I say that gets me my first proposition. I said I had to make two propositions. The first proposition is, even if it's not in the order, they say this is properly consequential upon reversal, it's the duty to order restitution of the principal sum.
In every case, irrespective of what the position is between the parties, apart from the order.
Can't at the moment think of any case where I would say there would be an exception.
Well, suppose there's a liquidated debt going the other way.
They might be able to.
Nevertheless, obligation to make an order for payment.
Yes, which could then be discharged by settlement of the debt. But one wouldn't not make the order, in part because you wouldn't then discharge the debt. You have to make the order that the sum has to be repaid for it to work as a discharge of the debt.
It does, among other things, at least presuppose that this went back to the Supreme Court of Hong Kong, and it was their duty to make the order. So one of the things I was struggling with earlier was that I think you were effectively saying the Supreme Court didn't need to do anything further than it did, and we were discussing what the remittal was about.
Mm-hmm.
Why didn't the remittal cover the equivalent of what the Supreme Court in Hong Kong was expected to do in this case?
The remittal is concerned with quantification of the summary judgments. Once they've set them aside, then cases like this show that the money should just come back. So you don't need to deal with it in remittal. You can, if you can't then reach agreement on it by the motion of restitution below. But that isn't part of the remittal, because the remittal is about dealing with the summary judgments, not the unwinding.
Well, I can see what this case is really about is interesting. It's saying that you've got to put the wronged party, you've got to put them back in the position they would have been wronged. And so that means that on the facts of this case, it seems to me it was the duty to order restitution. The battle was over the interest as well.
Mm-hmm.
I don't read this as authority opposition. But in every case, it is fairly and properly consequential upon the reversal a duty to order restitution. What it's saying is, where it is fairly and properly consequential, as on the facts of this case, it is the duty to order restitution.
In a sense, this is my Lord's question again posed to me, so I don't know if I'll do better second time around. I accept that's what the words say. Clearly. The question really is how fact sensitive, and upon what facts is it sensitive that the order must be made. Now, my Lord posited a case where there was another debt going the other way, and the hypothesis there was that you wouldn't order the money back. I have my answer to that, which is you have to say the money ought to come back in order to be able to discharge the debt.
Well, I'm not sure that is an answer. Earlier you said that you didn't think it really mattered what the jurisdictional basis was, whether it was restitutionary or something else. But assume for the moment that the basis for the claim is restitution. It's a claim for unjust enrichment, payment under an order that shouldn't have been made. Now we know there are all sorts of conditions that attach to an entitlement to an order for a payment of money on that cause of action. There are questions of change of position, but just in the example I gave you, it might be said the grounds on which you would fail to get an order for payment of money is that it wouldn't be just. The enrichment would not have been an unjust enrichment.
If it were unjust enrichment, I'm happy to say it's unjust enrichment because, as I say, I don't think it matters to me, and I think I get home if it is. I can explain why maybe now.
Yeah.
If the jurisdictional basis was, or the juridical basis was unjust enrichment, you would have to say there is an enrichment, it is at the expense of the claimant, and is it unjust? The Goff and Jones say, essentially, it follows just from the unwinding. You don't look at other possible duties that you had to pay, just as you don't anywhere else in the law of restitution that I'm aware. If you pay money under a contract and the contract is set aside, the money comes back. That's why.
It may raise arguments about change of position. It may raise arguments about having to make counter restitution. So there are all sorts of potentially fact-sensitive inquiries, which I know they don't arise in this case, but to test the argument, one has to take into account.
What I meant, I suppose, is there is an entitlement to restitution subject to the fourth question of defences. So your lord raises, my lord, your lordship, apologies, evocative, raises defences. I accept if there were defences, then they could be raised. But you only get to defences once you've gone through 1, 2, and 3 of the unjust enrichment analysis. Your lordship, though, was stopping at number 3, injustice, and saying it might not be unjust. But that, in my submission, is not the way unjust enrichment would look at it. It would say the claim has arisen from the obligation being set aside. Then query, are there any defences? And so, okay, yes, I accept there could be defences.
But does the entitlement, you talk about an entitlement to the money, does that not depend upon the application of defences?
Yes, ultimately, I accept that. So if it's unjust enrichment, then in theory there could be defences. There are none, I think, suggested here that fit within any of the ordinary forms of unjust enrichment. I don't think there's any suggestion, for example, change of position applies. But all I need to get through is 1, 2, and 3 to say prima facie the money should get back, that being enrichment at the expense of an injustice. And maybe I'll come back to Roger and Comptoir. Could I look at Goff and Jones now while we're on this point, which is at tab 18, page 325 of the authority. And paragraph 26.03, which is page 326. I'm not meaning to break new ground. I'm meaning to say that what the authors say in that paragraph is correct. And if I may, the other paragraph to show the court is paragraph 20.
Sorry,
Sorry, please.
it says the appellate court may then direct, or if no such order is made, a further order can be sought. I think your argument is the appellate court must then direct.
Well, I'm going back from that to this extent, my lord, that I'm accepting if it is unjust enrichment, then in theory there could be defences. So I think all I'm saying is they must, unless there are defences, but it's not a freewheeling discretion to do what's just. It has to be analysed according to the ordinary principles of law of unjust enrichment.
Yes, because the unjust element isn't a free-for-all as to what is or not fair.
And the unjust element here is if the order is set aside, and that's really what they say, then there is a policy that the money comes back absent, maybe restitution, things like that.
And that's what you're saying, Roger's authority for.
Yes. 2608 is paragraph page 329. Which is exactly what my lady just said. My lady just said.
I'm so
I said,
sorry, where are we going now?
It's still Goff and Jones, page 329, paragraph 26.08.
Yes, there it regards Roger as rated interest.
Yes. But maybe now I could look back at Roger on interest. I'm sorry for hopping about, but given that unjust enrichment question was raised, that's why I say, if it is unjust enrichment, we fall within it. Nothing that's been said against us recognises anything approaching defence to that. The second passage that I wanted to show the court on Roger was at page 240 of the bundle. And about 2/3 down there's a paragraph beginning, it is contended. And could I again ask the court to read a paragraph? Now I say that is my second proposition. Perfect judicial determination, which must be the object of all court to arrive at, will not have been arrived at unless persons who have had their money improperly taken from them have the money restored to them with interest during the time it's withheld. That's what I say it stands for. It's not just me, it's the editors of Goff and Jones. It's also how the proposition is understood more widely, it's outside this jurisdiction. Perhaps I could briefly show the court that. This is the supplementary authorities bundle, or the unagreed remission. Tab 1 in that is the case of the High Court of Australia. Which is very short. The passage I want is at page 6. And it's the paragraph beginning, restitutio in integrum is the right of every successful appellant. Now that's as it were the highest authority in Australia, so I may not need the other case, but I wanted to show that that remains how it's understood. So just probably for the court to note, that paragraph 60 of the Harlock case, which is tab 2 of this bundle, at page 31, the Chief Justice of New South Wales, Chief Justice Bell, says there is a quote, wealth of authority.
So which page are we on?
60. Sorry, 31, paragraph 60. A wealth of authority for the two propositions I saw just now. I accept, of course, that's Australia, not here, but the burden of showing McCormack was to show that those judges also agreed with my and Goff and Jones' interpretation of what Roger stands for.
In any case where somebody's paid money under a mistake of fact or a mistake of law now, or money hadn't received or paid for consideration that's wholly failed, all of these causes of action, you would say that the person who establishes that is entitled to restitution.
Yes.
And they're entitled to restitution with their money, with their interest in order to restore them to the correct position.
I would.
And isn't this saying no more than that's the same where you pay the money on the basis of an order which is set aside?
Yes, my lord, you said earlier, isn't that obvious when I raised that? And I say yes, and it's obvious here as well. So I say it is the same principle.
Yeah.
What I didn't want to get engaged in is there's a debate in Goff and Jones and elsewhere amongst scholars about whether it's the same genus or a different genus, and that restitution scholars can find arguments on all sorts of things.
But all of those causes of action would be subject to somebody being able to show that they have, for example, the right to set the money off.
Yes, and we don't deny that that could be done here.
Yes, I mean, presumably in relation to set-off, it's fundamental to set-off that you essentially need debts in both directions to be able to do a set-off. So as I understand your argument, you're saying there is a debt in our direction on which we should be entitled to interest, see the Roger case, and then yes, of course, we accept set-off, but you would say you have to go through those earlier stages first.
That's correct.
And you'd say what is said here is subject to defences, but that doesn't arise in the present case. Would you say this is
Well, a defence could be
not subject to defences?
I'm not aware of any defences that are recognised. So, my lord, for example, raised change of position. There is authority in unjust enrichment that change of position isn't available where it would stultify the course of action. So, a Woolwich claim, for example, you might not get a change of position. The same thing I think would follow here. I can't give your lordship any authority. I'm not aware of anyone ever litigating and arguing change of position on this quote unjust factor.
Well, more relevantly, it's not in play.
Yes. No, I was seeking to address that.
I mean, there are all sorts of reasons why the court refuses to make an order in restitution by reference to defences, whether it's counter restitution is necessary or there's sort of considerations. All I'm putting to you, and I don't, is that put in its bald terms here as a right to restitution with interest. I think you might qualify by subject to any valid defences, which don't arise in this case.
Yes, I accept that. It's the same as my lord's example of failure consideration that wholly fails. One's entitled to restitution, but if it's time barred, can't claim it, for example. But one doesn't usually say one doesn't have a right to restitution when there's a mistake of fact or anything like that, because there could be defences. So there is a right, but it's subject to defences. That's all I meant to say.
I understand.
I think given time, I might just say on Delta Petroleum, all I really wanted to take from it was that Lord Legate agrees with the decision in Roger and the Comptoir. He doesn't, in my submission, amend it, so it's not really necessary to go to it. I can just give the references if the court wishes to look at it later. It's at tab 16, page 268 of the bundle, but the relevant discussion of Lord Legate is, as it were, after the substantive appeal is determined, there's then the question of how to deal with the consequential order. And that's at paragraph 46 of Lord Legate's judgment, page 280. He then discusses Roger and the Comptoir without questioning it. I don't think he was meaning to. I don't read the judgment as amending it in any way. So I think probably I stand or fall on whether I can establish on the basis of Roger and the Comptoir. I say Delta Petroleum affirms it. Probably if there's advice in that submission, it's advice that would run through Delta as well. Maybe the one paragraph additional to cite is paragraph 50, which is at page 282.
You don't take anything additional from NICredit?
NICredit is discussed within Delta Petroleum. NICredit is per incuriam Roger, who wasn't referred to the board there. It's not clear to me that actually it advances things beyond Roger, and I think that's why Lord Legate says NICredit also gets it right, but NICredit is doing the same thing as...
Because it doesn't discuss Roger.
Yes. But NICredit is discussed in Lord Legate's judgment.
Yeah.
My only point, it was not to say that it's a problem for me, it's just to say I'm not sure that it really adds to what you get from Roger. And Lord Legate is then sweeping up both NICredit and Roger to say this is the law. But my reading of the passage is he's saying the law is just what's held in Roger for the reasons that Lord Keynes gave. He does say at paragraph 50, it's necessary to reverse transfers of money which have been made pursuant to the order set aside on appeal. I think there's a danger of trying to read judgments like statutes and going into too much detail on this. My reading is he's saying the same thing as Roger, but he does there state it in quite categorical terms. It's necessary to do so.
You need to read the following sentence as well. The position is analogous to that which obtains where, for example, the contract is rescinded. There is required to be a giving back and a taking back on both sides.
Yeah.
A restitutio in enter.
And the position in rescission in equity would be you do get interest as well under the court's general jurisdiction, and the law would be under section 35A. But maybe this is my Lord Justice Popplewell's point again. There might be countervailing things. If there's money going both ways, you might be set them off, something like that, as you would in rescission where there's mutual performance. Is that my Lord's point? Maybe not.
Well, I think the point is that I understood that you were suggesting that that Lord Legate was endorsing the idea that there would necessarily be a transfer of money following setting aside of an order.
Well, he doesn't say that there's necessarily a transfer. It's necessary to reverse transfers of money. It might be that you don't need to reverse a transfer by making an order for repayment if there are mutual debts going both ways. Yeah. But you do need to reverse each individual debt. It's just a question of the mechanism.
Well, as soon as the order is set aside, there is no debt.
Under the order.
There's no order, so there is no debt. There is no debt.
No, I agree.
No debt established by the order.
Yes.
So at that point, the recipient has money in his bank account, which is on the prima facie repayable to the payor. But if the recipient has debts owed by the payor or claims against the payor, he may be entitled to set off either by way of mutual debts or by equitable settlement.
Yes. No, I accept that, man.
At that point, it's in the court's discretion what it would do about counterbalancing interest entitlements.
Yes, I accept that too. I think that I was meaning to sweep up points like that with.
So what I find difficult at the moment is why, at the end of the day, this isn't all a matter for the judge to determine what should happen to these monies, and the counterbalancing payments of interest.
What's not a matter for the judge is to disregard the general legal principles. So if what your lordship said is correct, there's prima facie entitlement to be repaid. It's not a proper approach to the second stage of that your lordship is referring to, dealing with properties, to say, I will set off the money paid in 2016 and an order in 2016 and set aside in 2021, the later, the Supreme Court's actual order, under sums earned back in 2016. It's not a proper approach to that, because it's, well, maybe I should turn and say why I say what the judge did then is incoherent. The first thing I'd say is that he has disregarded the main submission I sought to develop this morning, that one is entitled to the money back. What he said is you're not. The question is what the order means. And he said that because he didn't agree with me, with my submission, that one has, as it were, this prima facie entitlement. That's in his first judgment, Core Bundle 5A, page 39. Now, the last two sentences are, I think, really the key ones. And the last sentence is the one that I'd say shows where the judge is going astray.
Is this paragraph 18?
Paragraph 18, I'm sorry, my lady, if I didn't say that, yes. The question isn't to determine what the order means. The order means the judgments are set aside. I've made my submissions on that. The question is what follows from that. And if what my lord said is the first sort of premise was correct, that there was prima facie entitlement, that then has to be recognised in some way. Except I then have to convince the court to recognise it in the way that I say. But that's not the way the judge is looking at it. The judge says it's simply a question of apportionment in 2016.
I wonder if the judge has gone so far wrong as you suggest here. It is notable, to put it mildly, the Supreme Court didn't make any provision for repayment. When one would expect that if they had set aside an order payment, that would be done.
Yeah.
I think the judge is at least entitled to ask the question of, well, what did the Supreme Court intend here? And by this order, and that does seem to me to be the first question: is what does the order entail? And the first thing to note is obviously this is a summary judgment order which is being set aside, not a final order. There is no determination here, your clients are not liable. It is a determination that the order for the summary judgment should be set aside. It is then remitting the claim on which the summary judgment was granted to the judge without ordering that the sum be paid back. In a situation where it is accepted, as I understood it, even at that time, that there were very substantial countervailing claims against your client, some of which were effectively recognised to be greater than this sum.
Well, can I just go back to something I asked earlier? Because the summary judgments were 7 different claimants. They related to the FIG claims. All of those claimants would be in different positions as regards whether indeed there were other claims, whether those claims were accepted or not. You've told us that at that time the 8.8, at least in 2016, the 8.8 million wasn't accepted. You've told us there's one other claimant where the FID amount exceeds, but I don't know the position of the others. So I'm less sure about the relevance of other amounts outstanding, to the extent it's relevant to try and work out what the Supreme Court.
Yes. Consonant with that, my lady, and hopefully responding to my lord, there was no evidence before the Supreme Court about what sums were outstanding at all. There's nothing in the statement of agreed facts and issues on it. Later, then there were these established value orders, as they're called, and those are the irreducible core for if limitations are issued. Those, on both the FIDs and the surplus ACT, do not exceed the 6.4 million. That's not true. So it's not until you have FI Supreme Court 3 plus Mr. Justice Richard's decision on the remitter and the limitation issue, you do get a sum greater than the sum paid in 2016 to which my defence clients are entitled.
Why is the judge necessarily wrong to say the Supreme Court said nothing about it? The judge would determine the claims. What is necessarily wrong about his construing that as meaning that the sums wouldn't be repaid in the interim?
It's not the question of whether they wouldn't be repaid in the interim. The question is how he ought to recognise what entitlements arise from the setting aside.
But if at the end of the day there is a claim is established for a sum of money which you accept there would be at least some sum established, then it wouldn't make sense for there to be a restitutionary right, at least to that extent, would there?
Well, I don't accept that, my lord, because can I put that in two stages, as it were? First is to explain why the Supreme Court did what it did in my submission. The second is why I don't accept the submission. For the first of those, could we look at supplementary bundle, page 100, paragraph 39 of my client's submissions to the Supreme Court. Now, my Lord's question was something like, the Supreme Court didn't...
Sorry, I'm not on the right page.
Sorry, page 100 of the supplementary. You'll see paragraph 39 at the bottom of the page. These are the submissions that we made on the summary judgments. You'll see at paragraph 39, HMRC didn't ask for the money back. And we might have been wrong not to do that, but that is a sufficient explanation for why the Supreme Court didn't do it. It's not, one can't infer, well, they must have thought there were cross claims and therefore it will have to be set aside later. They weren't asked to do it. So that is sufficient explanation why they don't include it, rightly or wrongly. Then the direct question is, as it were, supposing I'm wrong about that, and they thought it all has to be determined later, how to deal with that money. There's then the question of whether the approach the judge took. There are two rival questions. My approach is, as it were, do it today, set them aside. The judge's approach and my friend's approach is to say, do it back in 2016.
By do it, you mean set off.
Sorry, yes. Technical law.
So yes, because that's the real difference.
Yeah.
Are we setting off in 2016 or are we setting off now?
I agree entirely. And the setting off in 2016, which is what the judge does, is, in my submission, fallacious for, I think I have 4 reasons for that, in addition to the one I've already just given. But the one I've already given is, I had this entitlement, that as it were, as a building block. Then I say, the judge had, so this is my first reason, his analysis engages in legal, it has 3 legal fictions inherent within it. The first is, he must be deeming the 26th payment to have been paid towards something other than paragraph 1A of Mr. Justice Henderson's order. That's inherent in his analysis. But we know that's not true. The money was paid to discharge Mr. Justice Henderson's order. The next fiction is, it supposes the money in 2016 was to discharge a duty HMRC had to pay interest under the Finance Act 2019. Well, that obligation obviously didn't even exist in 2016 because the Finance Act hadn't been passed. And the next fiction, this will interrelate with the one I just made, is that it also supposes that the money in 2016 was paid to discharge a duty HMRC owed. As my lady says, that's necessary for the set-off analysis to work.
So I'd just go back to 2. Presupposes it's to discharge a duty under the 2019 Finance Act. That would mean that the judge had been applying it to discharge the Section 85 interest under the FID claims. Was that what the judge did?
So your Lordship's right. So the question is, should the money be applied to interest or principal? And then the question is, which interest? So my point is only, if he's thinking it's justifiable to apply it to interest, you can't do it to the 2019 Finance Act claim, which is the FID's claim, which is the one that my learned friend said it should go to first if he's wrong in the main appeal. But your Lordship is right, and I'm sorry for misstating the position. My understanding is he set it all off against the 35A in the first instance. So that also, I say, this is my third fiction, 35A does not give the claimants a debt claim, an entitlement. What it gives the court is a power to make an order that interest will be included in the judgment. We can look at the provision, and my assumption is that your Lordships and your Ladyship remember the provision. There may be included in any sum for which judgment is given simple interest. The court has a power to do that. The bit I showed the court on FI number 3, where they said it doesn't generate a debt, that's the same thing. So you have to suppose, contrary to legal fact, that there was a debt of that form, which is false. So there are 3 legal fictions in this, maybe 2, as my lord points out. And the point I make about that is that one should be very suspicious of any legal analysis that requires one to engage in legal fictions in order to get to the conclusion, particularly when the contrary view does not require any of them. You simply set off the debts today. That's my first point. My second point is that it puts the money entirely towards causes of action that weren't before the court in 2016. The only thing before the court were the FIDS claims. It's the only thing the judgment was about.
The rest was technically stayed at that time, wasn't it?
Evonik's well, yes, I think that's right. But the judge gives no justification for why that is the correct approach to set off against different causes of action, not before the court in 2016, that no entitlement had been established in respect of at that point.
But set off isn't a matter for the judge, is it? It's a matter for the. It be a matter for Evonik?
Well, Evonik couldn't set off something when they weren't entitled to. I mean, sorry, maybe I should put it this way. Evonik certainly didn't in 2016 set off sums paid in 2016
No,
against.
they've done it now.
I don't accept that, my lord. They can't years after the fact, when the judgment set aside, purport to set off in 2016 sums that weren't due at the time.
Well, they're setting off again. I mean, they're not doing it as of 2016, quite obviously.
But the logic of their position is that it has to be deemed to have taken place then. Because if they did it today, they'd be perfectly entitled. We wouldn't mind if they set off our entitlements against their entitlements to interest today, because that gets to the result, in a sense, that we argued for. What they want to set off is...
On the assumption that your entitlement includes an entitlement to Section 35A interest over the relevant period.
Yes. Yeah. Yes. What they need to get home on the judge's analysis and their analysis is that you have to deem this set-off to have taken place in 2016. Because that's the only way they can, as it were, get the quantification that they want.
Well, they either need that or they need to say that you're not entitled to interest on your restitution, or perhaps that you should be entitled to interest. It'd be more equitable for you to be entitled to an interest at, let's say, a Section 85
Yes.
rate.
Yes, of course. Now,
That, which is another way that neither party has argued, but...
No, that's right. So
Would,
that,
you know.
none of those are points they've ever taken.
Well, I know, but the court, as you accept yourself, it is up to the court whether to award interest and at what rate. Yes, I take the point about Roger, but one approach might be to think, well, Section 85 provides for a rate.
An approach might be. It is, of course, not the approach I would urge upon the court. And the reason is, I'd say, it would be, on principle, Section
Right.
85, I'm going to try to not merely assert, but to justify. Section 85 is there for a specific area of restitutionary interest, which does not, no one suggests applies to the revenue. So the question has to be, what, in general, is the revenue's entitlement under Section 35A? Senior court's that.
35, yeah,
What did I say?
85.
Yes, Section 35A. Very importantly, 35A, not 85. And that should just be the general law on it. One should not say HMRC's entitlements are cut down, in a sense, to relieve Evonik of Parliament's policy under Section 85. So Section 85 says, maybe look at it this way. Suppose no summary judgment applications have ever been brought at all, and the Supreme Court and FI, Supreme Court 3, determines the result. They get Section 85 interest. Orders are drawn up and they get Section 85 interest. HMRC would, in the interim, of course, have the use of the money that ultimately they have to pay to Evonik. Evonik gets their award under Section 85. No one could suggest, because it's the ratio of the Supreme Court's decision, that was an injustice to Evonik. Evonik would get the adequate indemnity required by EU law as found by Section 85.
Well, yes. It's another reason why I'm interested in what's going on elsewhere in the litigation, because one approach, standing right back, is to say, well, obviously, if Mr. Justice Henderson had had the right sort of crystal ball on his judicial desk, he probably wouldn't have made that summary judgment at all. In fact, he would have refused it in the same way that he refused it for the subsequent period, as we saw earlier.
Yes.
And if that's right, if that's the right premise, one approach is to seek to put the parties in the position that they would have been in if there had been no summary judgments.
Yes.
And other claimants who don't have FID claims, who didn't have the summary judgment but have surplus ACT claims, get their simple interest under Section 35A, and wouldn't have had the use of 6.4 million that was in 2016.
Yes. So that something like that was supposed to be the burden of my counterfactual and no summary judgments are brought. No one then could say it's unjust for them to get the Section 85A Section 85 interest. The question is whether by having brought summary judgments that we now know were wrongly brought because they recognise the wrong cause of action, Evonik should be in a better position. What they then do is escape. And this is, my learned friend is open about this. He wants to escape the result of both the Supreme Court's decision in Prudential and Parliament's policy under Section 85. That's really what the case is about.
Sorry, when you say prudential, you mean the compound interest decision?
Yeah. So the conjunction of those two things, Prudential plus Section 85, means that the entitlement in 2016 has been massively reduced. Everyone else who doesn't bring summary judgments, they have to live with that. Evonik says because we brought a summary judgment that incorrectly applied Central, we should avoid the Section 85 for the period in between. That's the, if we do it in terms of economic effects rather than legal analysis, that's the effect of what they want. And
It depends slightly what crystal balls you put on Mr. Justice Henderson's, as he then was, desk. The approach of Mr. Justice Richards in this case was to approach it on the basis that you look at the position in 2016 with a crystal ball into everything as it is now known, including the ACT surplus claims and the interest thereon, and you don't confine yourself simply to looking at the crystal ball in relation to the FID claims. Why is that the wrong approach?
I may be getting lost on the metaphor. The crystal ball. So the crystal ball is gazing into the future. Mr. Justice Richards, it's true, he knows all the facts about the past, but his analysis is inconsistent with them for the reasons I've just said. So he says you have to apply the money in 2016 to claims that weren't before the court, to which there was no entitlement.
Well, they were before the court in the sense that they'd been made. They weren't being adjudicated upon
Yes.
by Mr. Justice Henderson because he was looking at summary judgment in relation to a subset of the claims that had been made.
Well, they weren't before the court in that they were stayed. I accept there had been a claim form issued in respect of them.
Yeah.
But that's what I meant. They were not in front of Mr. Justice Henderson. He would have had no power to make any orders in respect of them. That was what I meant. So that is not the crystal ball for Mr. Justice Henderson.
That's why I was positing a different crystal ball which enabled whoever was dealing with all the claims to see what was going to happen to all the claims. I entirely accept that wouldn't have been available to Mr. Justice Henderson because he was looking at a limited subset of the claims.
Yes, I mean, I'm going to leave in this just to make sure I've made my point clear. It's true, Mr. Justice Richards, he then knows all the facts. One of the facts is that there is no entitlement that can be set off in 2016, that Mr. Justice Henderson couldn't have done that. So, insofar as his analysis is, as it was, we should apply the money paid in 2016 to the Section 35A interest. My submission is that is incoherent for the reasons I've said. Another reason is it's arbitrary. I think this is my third reason. For the reason, in a sense, I just gave to my lady, that all HMRC's entitlements will then entirely turn not only on whether summary judgments are brought, but also when the ultimate order for HMRC is drawn up. Suppose that HMRC had sought its money back, contrary to what I showed you they did, in front of the Supreme Court. The Supreme Court could not then have said, we're going to set it against the surplus ACT back in 2016, which couldn't do that. And they couldn't do that, of course, because it hadn't been established that those claims were in time. It can't.
But struggling with why it matters whether or not in 2016 any of this had been established, if in fact there was, as of 2016, an ACT surplus entitlement.
Well, so that there was an ACT surplus entitlement, which is the principal sum. That was, as it were, the declaratory theory tells us that that's what they were entitled to in 2016 in virtue of FI Supreme Court 3. That I accept is established, and that's really my ground too. The only thing that is established as a debt is that. Interest sums were not established as a debt in 2016 and couldn't be, because you can only do this when you enter a judgment at the time. So if we are in the realm of set-off of debts, you could only do it against the principal, and then I get to the same economic result.
Only by a goose and gander of treating your section 35 claim as an entitlement.
Were partly not
for set-off purposes.
But the debt, so that my debt claim is in the payment. I don't have any goose and gander about that, because my payment was a fixed sum, 6.4 million in 2016.
But why can't the judge say, well, if I'm setting off these two sums, I just ignore the interest?
Well, he could. That would be my ground too, wouldn't it? I mean, in the sense, he'd say, in 2016. Sorry, my lord, I didn't give a good answer to my lord. Do you mind if I try again? I hope will answer, my lord.
Yes.
There's no goose and gander in 2016, because the only claim we have in 2016 viewed, as it were, crystal ballish, is to the 6.4 million. There's no claim for interest on.
You didn't have a claim to the 6.4 million in 2016
I entirely
because so long as there's an order, there's no entitlement to repayment.
That's my first ground. If we're in the crystal ball world, Mr. Justice Henderson is then thrown back in time to redo it, which is something like what the judge says, and we're setting off in 2016, I don't need any portion of interest to be set off. All I need is the principal sum to get to the same economic result of what I say under ground one. That was my point. So it's not goose and gander, because I don't need any interest then. And I had, in saying I was going to answer my lord, forgotten what my lord's question was. I apologise. Do you mind saying again?
Well, I was asking when it comes to affecting the set-off, why does the judge have to deal with interest at all?
For my client, or in general?
Well, the set-off is mutual.
Yeah, so one thing he could do is set off, if viewed in 2016, ignore any claim that my client has to interest, ignore any claim my learned friend's client has to interest. Let's set off that then is ground two. In today, your ladyship will have to decide on this. You would have to say, my client just isn't entitled to interest. Maybe my learned friend isn't either under section 35A, because in principle it's discretionary. And you could do that subject to rules on the exercise of discretion, which I think brings me back to my submissions such as they were on Roger. Is that an answer to you?
You said you had 4 reasons. I think I've got 3 so far.
Yeah, the last one, fourth one, is fairness. So the judge's argument really was that this should be viewed as a matter of fairness. You see that most clearly in his second judgment, tab 5B, page 46. It's in the first judgment as well, and it's really my learned friend's case too. Paragraph 8. To the extent in my submission, this is the core of the judge's argument, that this is the fairest result. The law of restitution has been bedevilled by appeals like this to fairness, as my lord referred to earlier. And so again, this is not a sort of full thrust submission, but just a warning sign that when such references appear, they're no substitute for analysis if analysis can be done. But I do say engaging with the question on its merits rather than dodging it. There's nothing unfair in what we say, for the reason I gave my lady earlier. If the result had been no failed summary judgments were brought, the claimant in Evonik's position would get their Section 85 interest, and that would be the same economic position that on our analysis they would be in.
And they get 35A.
And they get 35A for the
surplus ACT.
Exactly.
That's one counterfactual. The other counterfactual is everybody knew what the true position is, as now known. And that was the exercise the judge thought he was doing.
Well,
If that's the right premise, then is there anything wrong with his conclusion about fairness?
I'm difficult to think myself into this world. So is the world, my lord, counterfactual world?
The counterfactual world is this money was paid in 2016, and what I, Mr. Justice Richards, are having to do is decide what the effect of that is in circumstances where I now know what the true position was in relation to all of Evonik's claims.
Yeah.
If the premise is that that is the right exercise, I put himself back in the position in 2016 when the payment was made of having all the crystal balls necessary to know what the true position was. If that's the premise, is there anything wrong with his argument on fairness that actually, given that there was a claim then for 8 million of principal on the ACT surplus and what would have been awarded to date then under section 35A of 11 million odd, that it would be fairest to allocate the 6.4 million to interest? Because that, as I understand it, is what he's doing here. And I understand you challenge the premise.
I understand the question.
But does it all really depend on where you start with your counterfactual, whether you only go to a counterfactual on what Mr. Justice Henderson was doing when he made the order, or you look at the counterfactual as what do we now know was the true position in 2016? It's just what I'm trying to tease out.
Yes, I understand. I'll try and see how I get on. The thing that was tripping me up was the reference to the counterfactual. So my counterfactual is something generally contrary to fact. Your Lordship's counterfactual, as I understand it, is to assume, I think, two things that aren't true rather than one. The first thing that is not true is that there is a Section 85 claim, because the FIDS claim is being brought. And so to the extent there's any claim under the FIDS that they have at the time, it would be that. Now, I think your Lordship would then say, no, I'm not assuming that, because it's only the ACT claim that all of this is set against, the surplus ACT and its interest for that. Now, the further thing you then have to assume, maybe there's multiple things that are not true, is that the surplus ACT claim had, as it were, the stay had been lifted. There have been the determinations in FI Supreme Court 3, and there have been the determination of Mr. Justice Jonathan Richards in the first instance. And if all of those things are known, and the claim was actually before the court, and a payment is then made, the reason why I express some difficulties, I find it difficult to think myself into a world where Mr. Justice Henderson says, knowing everything I do today, I order HMRC to pay 6.4 million. It's quite difficult then to make sense of what the fair thing to do would be. I would want to say the only fair thing, to the extent there's any fairness involved, would be to put it towards the FIDS claim, because those are the claims before the court. But your Lordship is asking me to assume contrary to fact all these further things, and that I then just find difficult because the counterfactual is so far from the conceivable world. It's not one. Mr. Justice Henderson would never order unspecified or specified sums to be paid to unspecified claims in 2016. So I'm sorry that
it's hard to get away from the reality that Mr. Justice Henderson just wouldn't have made a summary judgment decision.
Exactly.
I mean, that's implicit in his decision that he refused to make it for the later period.
Yes.
because he knew something was going on here.
Precisely because actually, if you run the chronology through, the second portion that he refuses to make a summary judgment in respect of is actually the thing that undoes the claimants in Prudential. Because what happens in Prudential, I think I have time to say this, is the dispute is over whether you can get that kind of post-utilisation interest compounded under the common law. The revenue had accepted Sempra interest for the period of prematurity. That's as it were the first part of Mr. Justice Henderson's order. Prudential, that was the test claimant in that group litigation, said HMRC were not entitled to argue that Prudential, were not entitled to compound interest because it would undermine the logic of Sempra Metals, and they've not challenged Sempra Metals. And the Supreme Court's decision was, you are right, it challenges the logic of Sempra Metals. Therefore, we have to overrule Sempra Metals. Therefore, there's no claim for Category A interests, called for the period of prematurity interest. Therefore, if you're Mr. Justice Henderson with your crystal ball, you don't order summary judgment for the FIDS Part 1, because you know what the Supreme Court will do is exactly the same as what you've just said for Part 2, which I think is just what my lady was saying, but to clarify. Time-wise, could I do a couple of sweep-up things and then there may be further questions? That was all I think I was going to say on fairness. My learned friend's case, he says my first ground has 3 critical flaws. I think I've dealt with all of these to the extent I can. This is in his skeleton argument at paragraph 42, page 146. I'll just say what he says they are and what my answer to them is.
Paragraph 42.
42 of respondent's skeleton argument for the appeal, page 146. His first point is what the Supreme Court did was only the interest rate applied as part of the summary judgment was set aside. Now that's the discussion we spent some time on this morning about what did the Supreme Court decide. You have my submissions on it such as they are. One additional point that I might make is that paragraph 52, Mr. Bremner does say, page 148 of this, had the Supreme Court wanted to overturn the payment obligation and require Evonik to repay it, it could have said so. It did not. As you might imagine, my answer to that is it wouldn't have done it because it wasn't asked to. And I could also raise a tu quoque. If the Supreme Court had wanted to do this sort of mutual adjusting, to say the payments have to be set off against things in 2016, it could have, but no one asked it to either. We don't get away from having to look at what the Supreme Court did order. Mr. Bremner's second alleged flaw is that his client was not unjustly enriched by 9. There's no entitlement to restitution. That's also a point that we've discussed, so I hope I've made my submissions clear on that. And the third alleged flaw is that there's no claim or counterclaim. And my point on that is the one I think I said to my Lord Justice Popplewell, that I didn't have to issue a claim form for this to arise. And anyway, if I did, I ought to be entitled to go away and do it, rather than have my claims set off in the past. Those are my answers, such as they are. There's one thing that I think I haven't answered, which is what Mr. Bremner says on the law, and the passage from Chitty and the older cases on apportionment of interest to principal. The judge, in his judgment, said essentially he didn't find these cases very helpful. That's his first judgment at paragraph 30, page 41. And in the second judgment at paragraph 7, page 46 of the core bundle, he says, I sort of stand by that, but I'll derive some principle of fairness from them. So he rows back a little bit, but still says he didn't find them very helpful. The things I wanted to say about them are twofold. At first, these are all cases where there was a payment from A to B, one party to another, where B owed both principal and interest, and it was uncertain what the payment went towards. Each of them had that form. Now, those aren't our facts. we know what the money went towards. It went to discharge Mr. Justice Henderson's second order. So in none of those cases does one engage in the sort of retrospective realignment, deeming that the judge engaged in here. So I say for that reason they're not applicable. Maybe I need to say three things. So my second thing is to say that so far as these are matters of fairness, I've already made my points on what the fair result is, and I'm not going to add to that. They're just rules of thumb fairness, as the judge says. I say that that doesn't help. And the third point is in none of these cases was one dealing with a provision like the Senior Courts Act or the Finance Act, where the court is called upon to give judgment for a debt or damages and is then empowered to make interest on top of it. They're all cases where there was an entitlement to interest that accrued day to day. And it therefore does make sense and it's conceivable to say the money was put towards that interest entitlement, contrary to what I say to happen in 2016 here. I don't need to go through all the cases. I don't think it would be in the court's interest. I'll just give two examples. The first is the Par Banking Company, which is a Authorities Bundle, tab 6, page 31. In that case, the defendant guaranteed the claimant's debts under a bank account. And so there's an entitlement to be paid interest under the contract, bank's contract, and the guarantee includes a promise to pay interest. You'll see that at page 32 at the top. Now the ratio of that case is actually that the obligation to pay interest on the guarantor is several from the obligation to pay the principal sum. And the way that proposition is manifest is that one is time barred and the other isn't. You can see that in Lord Justice A.L. Smith's judgment, which is very short, at pages 35 to 36. But I don't think the court needs to read that now. I'd say that illustrates the general point. There was an entitlement to interest and it's accruing, unlike this case from section 35A. The other case I wanted to look at was In re Morley's Estate, which is tab 7, page 39. Page 41, one will see the submissions of the legatees. So the question in that is about payments from an estate. Counsel for the legatees says the practice is that legatees are entitled to receive interest at a rate of 4% on their legacies. And the question is whether the money paid to the legatees in the interim before the estate was finalised should go to interest or principal. As I read it, the case says there's an entitlement to that 4%, that's what it's set against. Now, one thing I'll say just before I close is that the counsel in this case is remarkable. This is a decision before Mr. Justice Simons, as he then was, who becomes Lord Simons. Your Lordships in the later will see on that page Geoffrey Cross for the plaintiffs, future Lord Cross. Then F.R. Evershed KC, future Lord Evershed, leading future Lord Jenkins. Over the page, you see further on the future Lord Justice Romer, whose father at that point I think is in the House of Lords. Also the future Lord Justice Harman. What I wasn't able to find though is the next page, page 43 at the very top, there's an L.S. Falk. And I couldn't find who that was, I'm afraid. Unless the court has any other questions, may I turn behind me to ask if there's any other miss.
Say, in relation to the last submissions you're making, you say that in this case there's no doubt about what the payment was for because of the discharge of the summary judgment orders. But the problem with that argument is the summary judgment orders were set aside, so it wasn't in discharge of those orders. It was, and that's the whole point of restitution claims, is that it was for no purpose.
Well, the question is what was true at the time. So there's no uncertainty at the time that what they were being paid to do was discharge those orders. The fact those orders didn't exist, suppose we deem retrospectively they didn't exist at the time, the money was still being paid to discharge the non-existent obligation. There's no suggestion HMRC had any other intention. There's no evidential uncertainty to third.
Exactly.
It's true that orders are not by themselves set aside ab initio because the payment, they are valid until set aside.
Yeah. That's the Majira case. And so everything, all the Smith and East Ello is the old decision on this. So it's only if we're in the deeming world that we're saying Mr. Justice Henderson, as it were, no, it doesn't make the order. But then I find myself in what I said to Lord Justice Popplewell. It's a very, very remote counterfactual. And I'm not sure I understand. My lord, my lady, there is I'm told there is a computation point which is about the surplus ACT and its setup. I think it's a technical point, perhaps relating to my lady's questions that I was unable to answer at the start. I don't think it's going to be a point that would be trespassing, as it were. I think it's a point of clarification on the point of substance. So I propose, if my learned friend doesn't clarify when he sweeps up all my mistakes, that I could try and deal with it in reply.
Okay, it does occur to me, I'm not sure I fully understand also, this may be connected, why it matters to anyone that if the judge was entitled per ground 2 to allocate to interest, why it makes a difference that he's allocating to section 35A interest first rather than section 85?
It doesn't. It only matters.
I didn't think it did.
No, it doesn't, because we lose our money.
Yeah, because those are just numbers, aren't they? And
yeah.
Because you're not compounding, they're not affected by the allocation.
That's right. The only reason why.
But you said on a couple of occasions that the judge allocated it all to section 35A.
Yeah, so one point about that is the incoherence that the claims are not before him. The other point is, I did detect at least some sympathy at some point for the idea that, well, maybe some of it can go towards something at the time. The only way that I would say that could be close to coherence is on the FIDS claim, that it pays off for section 85. But then, the reason why, Mr. Bremner, and this is his respondent's notice point, pay off the FIDS first, then he says you prorate between principal and interest. If we get to there, then of course my answer is you don't prorate between principal and interest on section 35A. If you are in this counterfactual world where we're paying off, the only thing to be paid off is the FIDS, then the rest of it can't be allocated. So we then get our interest for the intervening period and our money back. That would be the only way in which going to one or the other could matter. It's only if consequently the court then was, as it were, with me, that one should stop there. But if the court isn't with me with that, it doesn't matter the jot whether it's one or the other first, financially.
Thank you.
Do you mind if sorry, just so I'm not trespassing on my friend? I'm going to have to discuss that, I'm afraid I don't understand it, so I will come back to it if I can. I apologise.
All right, let's see where we get.
I'm grateful.
Mr. Brennan.
I'm obliged. My lord, what I propose to do is to adopt the points we've set out in the skeleton and to develop my oral submissions under 5 broad headings. First of all, to start with the context in which this issue has arisen. Secondly, to address why we say the revenue is wrong to hypothesise a restitutionary claim for it to recover the 6.4 million plus interest. We say there's no such claim on the facts of this case. That's dealing with ground 1 of the revenues appeal. Thirdly, I'll turn to the issues my friend raised about allocation of the 6.4 million payment. So that's dealing with ground 2 of the revenues appeal. Fourthly, partly out of caution, give myself the chance to draw the threads together at that point and what we say is the correct analysis. And then fifthly and finally to address you on Evonik's alternative case, so that's the respondent's notice point, where if the court were to overturn the judge's analysis, we say the appropriate course would be for the 6.4 million to be allocated to the FID claim and then prorated. So that was the point that was just being touched on a moment ago, but I'll deal with that as if I may, at the end of my submissions. So please can I begin with the context? I wasn't proposing to go back over the ground that was covered in opening, but there are a couple of important points that I should emphasise. First of all, the starting point for all of this is that in June 2024, the judge was faced with the need to quantify Evonik's successful claims. And what the judge needed to do in that context, in my submission, is to undertake that exercise by reference to matters as they were understood at the time he came to make his decision. And in particular, not by reference to how they might have stood in the past if different steps had been taken or different rulings had been made. And the observation that the judge made at paragraph 24 of his first judgment, so page 40 in the core bundle, was in my submission exactly on point. What he was dealing with was Evonik's application for judgment. That was made, and we can come back to the history of this to the extent we need to, but that was made after the judge's ruling on the limitation issue in February 24 in the Bat Industries case, what we have come to call FII High Court 3 in the jargon of this litigation.
So this is after BAT, after the
Yes, that's right.
litigation decision.
That's right. So at this point in time, Evonik, which was a party to that Bat Industries decision, judgment at the start of February 2024, it says because the judge had ruled that the date of constructive discovery, he'd said it was the date of the Foucaultian judgment. And this court has adjusted that to say it was the date of the Advocate General in Foucaultian. It doesn't matter for our purposes because it moves the date back by, I think it's about 6 months. It goes from June 2000 to, I think, December 1999. Evonik had issued its claim in June 2002, so it doesn't matter. Evonik's claim is in time. And at that point, Evonik says, right, here's the quantification of our claim to the revenue, and it says to the court, we would now like an order, please, for judgment. We know there might be an appeal, but we want judgment now. There were, as it happens, some wrinkles, and one of the wrinkles is discussed in the skeleton. There was the sort of excursus where Evonik said, well, actually, we think we might be entitled to some more money. And the judge said, well, there was an admission, you're not entitled to withdraw it. There was an appeal to this court, permission was refused. So those aspects that are canvassed in the skeletons, this court today can put a line through. That doesn't matter anymore. But that was the point that we'd reached. It's Evonik saying, we would now like recognition of what's owed to us. And it's the quantification of that entitlement that the judge is dealing with. And the 3 steps that he sets out in paragraph 24, they in my submission, and I'll develop this, get the judge to asking the right questions. So what is Evonik due? How much has been paid already? And then third, in the light of the 6.4 million that had been paid, what interest is due? So that's the starting point in terms of what the judge was doing. Second point, in terms of what Evonik is entitled to, we know that where Evonik overpaid the tax, then Evonik is entitled to the return of that tax with interest. Interest is part of the San Giorgio right. That's through the adequate indemnity concept. And we also know that where Evonik paid tax too early, Evonik is entitled to the return of the time value of the tax and also interest on the time value amount. That was established in the European Court many years ago now in the Hearst case. It's also recognised, and I may need to show the court this later, but it's recognised by the Supreme Court in its judgment in Prudential, paragraph 78, and we'll look at that if we need to. It's on the basis of those entitlements that the judge found that the Evonik claim was worth £22.5 million, roughly, as at the 23rd of March 2016. Those are the figures he records in paragraph 25 of his judgment. and that's comprising the three elements: the overpaid tax, so that was the surplus ACT. Second, interest on that overpaid tax, and then third, time value amounts in respect of the FID claims. And one adds together the 8.8, the 11.4, and the 2.3 million, and one gets to the 22.5 million. Just pausing there, I recall my Lady Justice Falk, I think, raising a question about whether there was a difference between the FID ACT claims and the surplus ACT claims, or asking what the nature of the surplus ACT claims was. And I think the answer is, but we can double check this if it matters. When we're talking about surplus ACT, that is advanced corporation tax which either has not been returned to the claimant, just simply because the revenue's still got it, or it is advanced corporation tax which was set off against unlawful mainstream corporation tax. I don't really want to get into the detail of this, but the court will remember under the system, it was section 239 of the Income and Corporation Taxes Act 1988. What was supposed to happen was a company which paid ACT, there was an automatic set-off against the mainstream corporation tax liability. One of the problems that the Supreme Court had to deal with in Prudential was you might have an undifferentiated fund of ACT. Some of the ACT might be lawful, some unlawful. Some of the MCT might be lawful, some might be unlawful. We live in a world where the Supreme Court held in Prudential there is no restitutionary claim for lawful ACT utilised against unlawful MCT. However, if one is looking at unlawful ACT utilised against unlawful MCT, those amounts are treated in the same way as surplus ACT.
So your surplus ACT claims are just not been set off, or it was unlawful ACT set off against?
Unlawful ACT, yes, that's right. Not set off at all because the conditions weren't satisfied, or it was unlawful ACT set off against unlawful MCT. I hope that helps with the answer. And it probably is enough for now. And of course, my lady will be well aware the point under the FID regime, they were the statutory provisions which made provision for the FID ACT to be repaid.
Yeah.
So FID ACT one would expect to generate a time value amount.
Yeah.
The only wrinkle with that is if repayment happens after the claim has been issued. That was what we thought happened, and why the extra application before the judge happened. But as I say, that didn't get anywhere.
So we ignore that. All this ACT was in fact repaid.
For the FID ACT, yes, correct. That's why we are only dealing with time value amounts, and why ultimately we are dealing with the Section 85 remedy. I hope that helps with the question. So those are the elements of the claim, and then what the judge was dealing with is a situation where, looking at the matter in June 2024, and indeed looking at the matter now, we know that the revenue owed Evonik very considerably more than the 6.4 million that it had paid, and that's an important point. And it's an important aspect of the judge's analysis, because if we look at this claim, and I'll be emphasising that there is only one claim. My learned friend does try to make something of separate causes of action and points like that, and I'll come on to deal with that. But if we're looking at this claim, it is Evonik which has been kept out of its money. The summary judgment was summary judgment on part of the claim. That was set out expressly in paragraph 1 of the 22nd of January 2016 order, which is in the supplementary bundle at page 30. We looked at it with my learned friend. It's summary judgment in respect of the parts of the claimant's claims concerning advanced corporation tax on foreign income dividends. And actually, this is ancient history now. But one of the issues that Mr. Justice Henderson did canvass in his judgment that led to that order was the question of could you have summary judgment on part of a claim. There was an issue about whether that was an apt situation to have summary judgment at all. But in my submission, what we're looking at is a circumstance where, yes, of course, there is this payment of 6.4 million in March 2016. That is, we'll see, simply and best regarded as a payment of an amount that ultimately goes towards the amount found to be due to the claimants. It's wrong, as the revenue seeks to do, to seek to hypothesise a claim on the revenue's part to recover that payment and also apply interest to that claim. And what I'll seek to show is that none of the cases, not Roger, not Knight Credit, not Delta Petroleum, none of them establish the absolute entitlement that the revenue needs in order to make their analysis work. Their authority for a more nuanced approach. The court has jurisdiction to make the consequential orders that justice requires, but in this case, justice does not require the reduction of Evonik's claim in the way that the revenue suggests.
I thought the case for an absolute right was rather abandoned.
It does seem to have been rowed back from, that's right. But even looking at what remains of it, what I say is one has to look actually at the justice of the situation. That's exactly what the judge did. And his exercise of discretion, that evaluation, is not one that should be being overturned on appeal. What my learned friend has to do, and this is why he's no doubt put his grounds in the way that he has to show some error of principle. You can't just quarrel with the weighing up exercise, and that's why the burden of my submission is going to be to look at each of the two grounds and to show that this was something the judge was entitled to do, and there was no error under ground one in rejecting the proposition that there was a claim coming from the other direction, if I can put it that way, coming from the revenues direction which attracted interest. That wasn't an error. And secondly, there was no incoherence, as my learned friend suggests, in the allocation that was actually done.
When you look at money being paid at a particular stage of a long-standing relationship, for a better word, is it a matter of broad discretion for a judge as to how you allocate those monies and interest thereon, or does that have to be done as a matter of proper legal principle?
It's informed by legal principle, but what the judge ultimately was doing was making an award of Section 35 capital A interest in Evonik's favour. That was a discretionary award. There is, and I made this submission below, there's a floor to the award. In this sense, EU law mandates, and I'll show you briefly Littlewoods if you want to see it, that the award of interest cannot be less than an adequate indemnity. So it cannot be the case, for example, that the court says, you have an entitlement to interest, but we award you interest at 0%. Nor could the court say, well, we're going to cancel or not recognise your claim for interest for particular periods. But ultimately, that was the exercise the judge was dealing with. It was the...
You just said there's a flaw in what he did.
I'm sorry, a floor, F-L-O-O-R.
Oh,
very
okay.
a floor to the discretion. That's a very important distinction.
Yes.
I'm very grateful for my lady's question, because that would have been very unfortunate if that had remained on the transcript.
But you're not going so far as are you to say that EU law therefore mandated what the judge did?
No, I'm not
do.
saying that.
I didn't understand you to be arguing, for example, that HMR's case contravened what European law requires.
And I don't need to say that.
Okay.
And I'll explain why.
Does it come down to the end of the day saying that for all the arguments about restitution, what this really comes down to is how much interest you get, and that's a matter of Section 35 5A.
Yes, and I'm going to develop that. But perhaps clocks all seem to be at various different times. I think on my watch I have another couple of minutes, which I'm very happy to continue with. But looking at that one, it's after 2. I'm very much in the court's
Well,
hands.
choose a convenient moment. If that's a convenient moment
I'm very grateful. I was just about to turn to the detail of Grand 1, and just a signpost. I think the court will know where I'm going from the skeleton. I'm going to deal with this in 3 chapters. The first is to address you on the effect of the Supreme Court's judgment and order, where we say the 2016 summary judgment, it wasn't set aside in its entirety. What was being required was for the amount due to Evonik to be recomputed. Second, there's no unjust enrichment, nor is there anything in the court's inherent jurisdiction that would justify an award of interest in the revenue's favour on the 6.4 million. And lastly, there is no claim by the revenue for the return of the 6.4 million. So they're the points I'll come to, if I may, after the short adjournment in responding on Ground 1, which is my topic 2.
Yes, thank you. Right, 2 o'clock.
I'm obliged.
Court rise if able.